Where did you get this?
I took it myself.
Oh.
With my own camera.
Where is this? I couldn't find it.
Yeah, you know where North, what is it? Blackburn Road
Oh,
is?
yeah. Okay.
When you go, you know,
This is a meeting of the Athens Board of
on this
Zoning
avenue at
Appeals.
the end, you go to 50.
The time is 7 o'clock,
You just go
and
for a
it
bit,
is
maybe
March the
half a mile, and you take a
14th.
right, go
At this
all the
time,
way
I'll
up the
call the
hill,
meeting to
and
order.
then turn a right. That's a new subdivision.
The board consists of 5 members and an alternate. The alternate takes
here,
the full
no,
part
this
in the
is,
discussions in becoming a voting member in the absence of a member, or when a member abstains for conflict of interest. Present tonight are Mr. Shafee on my left, and Mr. Golsey, and Greg Lavelle, Roger Gruzier, and Betty Hollow, the chair tonight. And with us are Mr. Pearson of the Code Office and Acting Secretary Paul Eschenbach. I'm not sure we have anybody from the law office tonight. I don't believe that we did. Oh, we did. Okay, Mr. Miller, thank you. The board operates according to the following procedure. The chair will name and describe the case. The zoning administrator will state the basis of the objection and any applicable facts or conditions pertaining to the case. The applicant or their representative will give reason why the appeal should be viewed favorably. Anyone wishing to speak in favor of the request will be heard. Anyone wishing to speak in general comment will be heard. Anyone wishing to speak in opposition will be heard. If necessary, the appellant or their or their representative will offer concluding summary or rebuttal remarks. Testimony from the floor will be closed and the board will deliberate and render a decision. According to Athens City Code Section 230703B, the board has the power to grant variances from the strict application of the code, provided the variance will not be contrary to the public interest, the spirit of the code is observed, public safety and welfare secured, and substantial justice is done. According to the Athens City Code Section 230910C, variances from the code shall not be granted unless the board finds, based on direct, specific findings of fact, that each of the following conditions has been supported. 1. Practical difficulty and undue hardship. Because of exceptional or extraordinary circumstances or conditions pertaining to a specific piece of property, a literal enforcement of these regulations will result in practical difficulty or undue hardship that is unnecessary to the achievement of public purposes. Excuse me. 2. Exceptional circumstances. There are exceptional or extraordinary circumstances or conditions applying to the property in question or to the intended use of the property that do not apply generally to other properties or classes or uses in the same zone. 3. Preservation of equal property rights. Literal interpretation of these regulations would deprive the appellant of rights commonly enjoyed by others in the same zone and the same vicinity, while a granting of the requested variance will not convey on the applicant any special privilege that is denied to other properties in the same zone and the same vicinity. 4. Minimum variance. The variance granted is the minimum variance required to make possible the reasonable use of the property. 5. Absence of detriment. The authorizing of such variance will not be of substantial detriment to adjacent property and will not materially impair the purpose of the zoning code or the public interest. 6. Not of a general nature. The condition or situation of the specific piece of property or the intended use of said property for which variance is sought, one or the other or in combination, is not of so general or recurrent in nature as to make reasonably practical the formulation of a general regulation for such condition or situation. The board also has the power to review decisions of the zoning administrator, hear requests for conditionally permitted uses, hear requests for substitution of non-conforming uses, determine the number of required off-street parking spaces if the specific use is not contained in Section 2311 Table B, hear requests for temporary use of structures or premises, and consider requests for extension of temporary permits after receiving a recommendation from the Athens City Planning Commission. Any person, resident, or officer, department, or appointed body of the City of Athens aggrieved by a decision of the board may petition the Athens County Court of Common Pleas concerning the illegality of the decision. Such petition must be filed within 30 days after the mailing of the decision of the board to the applicant. There are 4 cases on tonight's agenda. Case 0603V is at 30 Westfield Place. case 0604B is at 181 West State Street. Case 0605B is at 316 Carroll Road, and case 0607B is 13 Lawson's Way. The board is required to take testimony under oath. Would anyone wishing to speak concerning any item on the agenda please stand and confirm that you do swear or affirm the testimony you will give to the board to be the truth, the whole truth, and nothing but the truth? Thank you.
I'll let him know this is not here, just in case.
Yes, the first thing we need to deal with, and some of you are certainly concerned with this, is case 06B, which obviously I did not refer to, at 150 Grosvenor Street. The appellant, John Patakis, has withdrawn his case without prejudice, so we will not be hearing that case. If you came for that, you can happily go home. Our first case is 0603B at 30 Westfield Place. The appellant is Cecilia Hanson. And I think we'll ask Mr. Pearson if he will come up and speak about this case.
Just for the record, my name is Steve Pearson. I'm the zoning administrator for the city of Athens, Ohio. The property in question, 30 Westfield Place, is part of a major subdivision that was recommended for approval by the Planning Commission and approved by City Council several years ago. It's just about to the point now where it's built out. Just about all the structures that were originally proposed have been constructed. Westfield started out as a planned unit development, in other words, construction of multiple buildings on a single parcel of land. Toward the end of the review process, it was proposed as a major subdivision, so each individual owner of Westfield owns a small portion of property also. There were several variances that had to be granted to accommodate that. For example, 0 lot line, 0 setback, those kinds of things for the lot configuration. But the whole project was reviewed and approved by the Planning Commission and City Council. There were some development issues there because of the nature of the soils. They were very slip prone. And the area that the developers wanted to concentrate on was less likely to have slip potential. Therefore, the right-of-way was narrowed. Variance was granted for that, and variances were granted to construct all the buildings closer than this to the street. So if you wondered why, if you went out there and looked at it and wondered why everything seemed close to the street, is because those variances were granted by the City Council with the review of the subdivision. At the time the developers came in to review the project, it was presented as a totally owner-occupied development. There was no intention for any of the places. I don't know if there was ever said that it wouldn't be rental. It was just said that it was intended to be owner-occupied. There are some small areas off the side of the street that are parking for everyone. Those spaces are not dedicated to any one particular property. They're in the city right-of-way, and they're essentially the same as on-street parking. That was one of the concerns too, because the road and the right-of-way were narrowed. There wouldn't be any ability to park on the street. Where would visitors park? Because the houses were so close and the driveways then so short up to the buildings. I'm not sure if there are any deed restrictions or subdivision covenants that cover this. That they have to stay owner-occupied and not be converted to rental. That situation, though, would not be something that the city would enforce. That would be something civil between, say, the homeowners association and a particular property owner. So I have no knowledge one way or the other if there are any deed restrictions or covenants associated.
Well, Steve, this is like one of the cases that if we have the deed, it would be just clear. And if it says in there, it has to be family occupied, then we don't even have to have this hearing, or you can't issue the permit.
I do have a copy of the deeds in the file. It does not have that in it. but I don't have a copy of the subdivision covenant if one does in fact exist. So, the request is for a variance. You have to have a minimum of 2 parking spots, but this zone happens to be R3 multifamily residential. The parking requirements for not being able to stack cars is zone driven and not use driven. I know it comes up quite often. Just because it's a single family use where stacking is permitted in an R1 zone or an R2 zone, stacking is not permitted in an R3 zone. So that's the difference. The stacking prohibition is zone driven, not use driven. In the Green Hills subdivision, just adjacent to this, as you drive in, the board has in the past granted 2 variances for stacked parking in that particular subdivision. It was zoned R3 at the time. Just recently, City Council, on petition of the property owners in that subdivision, rezoned that area to R1. So even though those variances were granted for stacking, they're not necessary now because the zoning change from R3 to R1 allows stacking in Green Hills subdivision now.
Have you issued any rental permit in that subdivision for anybody else?
In Westfield Place? No, this is the first request for it. As you know, as we've discussed before, and it's common knowledge, at least amongst the board members, variances are granted for properties and not persons. So the variance, when granted, continues with the property forever. As I was sitting here thinking of another possible solution to this, and I just kind of throw this out for the board's consideration. Recently, a temporary use was granted to Mr. Coladas for his mother's home on West State Street. He didn't intend to rent the property for all that long. He wanted to sell it, and then the buyer, if they wanted to convert it to a rental, would have to cope with the parking situation. So the board looked at a temporary use request for Mr. Coladas. When on the introduction to the meeting, temporary use is something the board can consider. Temporary uses can be granted for the board by myself for up to 60 days, by the board for up to 1 year, with recommendation from the Planning Commission on review after that first year for the potential of up to 3 years. So I'd just kind of like to throw that out. I didn't advertise it that way. I don't think we can hear a request for temporary use, but then there's the potential if the request for a variance would happen to fail. Just think of that. I mean, that's another possibility to consider a temporary use. And the board has done that before, even very recently. Unless you have any questions for me, that's all I have.
Questions, anybody? Thank you very much.
Yep, you're welcome.
Now we'll hear from the appellant. And if you'll just state your name and address for the record, that would be good.
My name is Cecilia Hanson, and the address is 30 Westfield Place. I guess what I kind of explained in my appeal letter is that this isn't a property that I intend to keep as a rental. I'm currently a med student and am completing my clerkship in Columbus, Ohio. And so, as a result, I also own this home, and I will be returning back to Athens after my clerkship is done, which is in a year and a half. And so, because I can't afford to pay for my house and also an apartment in Columbus, I went to some friends that were looking for a decent place to live, and so that's who's is currently staying in my house right now. And so prior to this, though, I did go to Ohio Realtor, which is, I believe, owned by Mr. Wharton, who did say that he had obtained the permit and everything like that. So, I didn't even know that I initially was not in the correct, because I wasn't trying to slip anything under anyone. It wasn't until I was contacted by the zoning commission and informed that I didn't have a permit on file. But I do have I had a contract with Mr. Wharton, and he had told me that he obtained all the papers. So, my appeal is based upon financial hardship, but I guess I'm looking for the zoning committee for any recommendations. I recommended either I can put it in my contract that only one person can have a car, or if I could work out some sort of deal with Soul and Bloom where some of the temporary parking that they did build, if they could devote one of them to my house. Those were two of the solutions that I came up with.
Questions?
I think financial difficulty, hardship, we cannot consider because it goes with the property. Would you be open to suggestion that Mr. Pearson made on regarding conditional, or was it temporary permit?
Definitely. As I told you, I don't plan on keeping this as a 10-year rental. I'm just a student trying to get through. And then eventually this house will be sold as soon as I'm out of Athens.
And when would you be out of Athens?
Probably, well, I'm actually coming back to Athens, I think in about a year and a half.
After that, you're coming back in a year and a half?
Yeah, so I would need a permit or a temporary permit for about a year and a half. And then I'm coming back and I will be living in my house. And then after I leave, I'm selling. So this is not the business for me.
Well, and I think you understand, as Mr. Pearson pointed out, that the variance goes with the property, not you, and it sticks on that property then pretty much as long as the property exists, unless something dramatic happens. So, yeah. Any other questions? Anybody? Thank you very much. You'll have a chance to come back and say something at the end if you'd like to do that.
Okay. Or can I say something and just wait until then?
Well, you can say it now if you
I
like,
just
or you
want-
say it twice if you like.
Well, I just wanted to thank the zoning committee just for allowing me to come up here and at least state my case. And I really appreciate all the information that you provided too. And I am very open to that suggestion of the temporary permit.
Okay. Thank you. At this time, we will like to hear from anybody who is in favor of this variance. Anybody who wishes to speak in general comment? Anybody in opposition? Yes. Okay, so if anybody wishes to speak in opposition, and let me just say at the beginning, if we have a number of people, and it looks as if we may, you should either speak briefly or make different points. Okay, so who'd like to come first? Yes. And again, will you state your name and address?
Yes, thank you. My name is Sharon Fink, and I live at 35 Westfield Place, which is directly across the street. Just a little bit of background. We currently have 60 single-family dwellings in this neighborhood, with 2 additional dwellings currently under construction and possibly plans for a few more. There are currently only 5 pads for guest parking, which provides approximately only 7 spaces for 17 vehicles. 2 to 3 more if you count the area where the mailboxes are located. As pointed out by Mr. Pearson, the streets are extremely narrow. It's wide enough for 2 cars to pass if there is no one parked on the street, and currently parking is only allowed on one side of the street because the streets are fairly narrow. And so as it stands now, when people are in the neighborhood and people in the neighborhood have social gatherings, it's very challenging for them to find some place to park. While this one variance alone might not create a hardship, I am concerned for the precedents it would set if this were given a permanent status. I believe that this neighborhood was designed for single-family occupancy, not multiple-person rental occupancy, and parking will become a greater problem if the makeup of the community changes to accommodate occupancies of 3 unrelated persons per dwelling. So I'm really concerned about the precedents that this would set. Perhaps a temporary variance would be something that we could accommodate, but I am very concerned with there will be no control over what will happen in the future if this is granted, and the precedents it will set for other units in our neighborhood. So that's all I have.
Thank you. Yes.
Good evening. My name is Anita James, and I live at 27 Westfield Place, and would like to point out a couple of things that are different points than what Sharon presented. First, there is a set of deed restrictions that we all signed when each of us purchased our property. Item number 9 of the deed restriction says that each lot owner shall provide parking space for vehicles on his own property, and continues with no trucks, no commercial vehicles. Item number 19, which is even more to the point, says several pocket parking areas will be developed within Westfield Place for the purpose of providing additional visitor parking areas within this residential area. These spots will be maintained and regulated by the Homeowners Association once established. Storage parking or use of these spots by specific lot owners for purposes other than short-term visitors is expressly disallowed. With respect to the 6 criteria under which the zoning board may make or may permit variances, let me respond to 4 of those that I believe are pertinent to this case tonight. First, there are no exceptional or extraordinary conditions applying. The conditions applying to 30 Westfield are the same conditions applying to all of the homeowners in the subdivision. Second, there are also no exceptional or extraordinary circumstances that do not apply to all of the property owners. Third criterion, a literal interpretation would not deprive the applicant of rights commonly enjoyed by others. However, if the variance is granted, it would give a right to her or to that property not enjoyed by any of the other property owners. And then finally, in response to criterion number 4, at this point, that property has been able to make reasonable use of the property, so there has been no hardship, inconvenience, or other use of the property up to this point in time. And so I would argue, as did Sharon, that the setting of a precedent for this issuance of a variance, I think, has a serious portent for the remaining property owners in Westfield Place.
Thank you. Anybody else?
She needs to be sworn in.
Oh, yes, everyone else was sworn in when they came in, and you were not. So let us see what you need to say. You just need to say that you will tell us the truth and nothing else.
I swear I will tell the truth.
Thank you. Okay.
My name is Chris Nisley, and I live on the south side, and I'm representing the South Side Community Association tonight, and so I have a statement that the executive committee has reviewed and approved and requests to be submitted. In Athens, it's very common for residents to spend 1 or 2 years out of town and rent their homes while they are gone. We support this practice and appreciate the possibility that a homeowner might need to rent to 2 unrelated persons. Since this situation might occur often, we do not think it should be addressed by the Board of Zoning Appeals as a variance to existing code, but rather by City Council in the form of new legislation. This situation should be time-limited, not open-ended as allowed by a variance. To grant this variance would create a precedent that could potentially cause harm to neighborhood properties. Therefore, we request that you deny the appeal and suggest City Council consider addressing the problem with legislation that allows short-term, time-limited, non-renewable permits for 2 unrelated renters. Thank you.
Hello, my name is Bojanka Bishop, and I live at 37 Westfield Place, which is almost directly across the street from the property. And I concur with what my neighbors have said, and I'm going to speak from a personal perspective. I know that the streets are very narrow and parking is very difficult, and sometimes even if people are parked on the street, when you're backing out of your driveway, it's dangerous, and it's risky that you might accidentally back into somebody. So I think we have a very difficult parking situation there, and I just hope that we don't grant this variance, and because it will basically create a different neighborhood situation. Almost all of us are owner occupants, or all of us,
And I think that we want to make sure that we keep the neighborhood safe and we take care of the parking that we need to, and that each person takes care of the parking in their own driveways. Thank you.
My name is Marty Rector, and I live at 32 Westfield Place, which is right next door, and I would hope that the variance is not granted because, as we've said, all the neighbors have said, it's the parking is very limited and the streets are very narrow, and I just don't want to see the neighborhood turned into that kind of a situation where the parking gets to be very limited like that. So thank you.
Thank you. Anyone else? Okay. Yes, go ahead.
There are two things I'd like to respond to. One of them had to do with Southside Neighborhood Association's recommendation of an ordinance change. The housing code, as it exists today, does have that provision, but that ability to have someone other than the owner live in a property is done without a permit for a maximum of 6 months. So there is a section in there that says it's not a rental, but someone can essentially house sit for you for 6 months. So maybe just tweaking that little section of the housing code is a potential to make that time period more than 6 months. And another thing I'd like to say too is if Ms. Hanson has someone house sitting for her right now, that's not a problem, that's not a violation of law. The housing code says that you can have someone living in a property, but you do so at your own risk, at your own peril, until you've been able to obtain a permit. I think she's showing good faith that someone is living there to try to obtain the proper permits. And again, as I said, she could have somebody just come and house sit for up to 6 months, and a rental permit wouldn't even be necessary. But we're talking about a more extended period of time than that. So just those two things.
Steve, if we consider that temporary permit maybe later on, would the stacked parking be allowed then?
In the case of Mr. Coladas on State Street, had the same thing. It was the car is in an R3 zone. The cars were stacked in the driveway. So there was just an understanding that yes, the parking would be stacked for this short period of time. I remember from that particular case, though, too, there was someone who came in and said that the backing out of single wide driveways in some of these congested areas was a problem. This is not a congested area. There's not a whole lot of traffic. It's a dead-end cul-de-sac, but there still are some challenges on the narrow street and with parking allowed on one side to get out of some of the driveways. So there wasn't a variance granted, to answer your question, with that temporary use, just an understanding that the parking was stacked.
Thanks.
Thank you. Yes?
Define what stacked parking is.
We use the term a lot, stacked parking. The code doesn't say stacked parking. What it says is that except in R1 and R2 zoning districts, there shall be adequate provision for ingress and egress to all parking spaces. So that's the stacking code. So adequate provision for ingress and egress has been determined to be the ability for each car to be able to move without moving one other car. So, stacking is just kind of the term that's been attached to it. It has to do, technically it has to do with access to the street by each vehicle independently of moving another.
Okay, thank you. Ms. Hanson, would you like to have the last word?
If lady there raised her hand.
Oh, I'm sorry. We're going to ask Ms. Hanson to wait just a minute and see if we've got another question.
Yeah, I'm sorry. I'm not sure that I made my point clear, that I think because we're talking about temporary permit here, I would be against the temporary, is even if it were not permanent, we still have the problem of the stacked parking, limited parking, not enough spaces for each car. So whether it's, even if it's a temporary situation, we still have a problem. So I think we have to,
Well, to answer your question, if there was a family with 3 cars, they could stack in there without you having any objection to it, you couldn't, if there was like a family with 3 or 4
That's not
cars.
really true.
Well, a single family
It's an R1, R3 district, so you can't have a stacked parking
at
no
all.
matter who's in the house.
Not even for a family.
Well, that's, no, the parking requirement, the only reason the stacking kicks in is because there's a request for a rental permit. So,
So if it was a single family, they can park as many cars.
Okay, sorry about that.
Okay.
Families can do anything.
Yes.
yeah, I think another thing I want to clarify, maybe just for Ms. Bishop, you cannot hear a request for a temporary use tonight.
We understand that.
That situation arose at 108 Grosvenor. There was a request for a narrow driveway to access parking spots. There was some discussion then about, well, could you lease spots somewhere else? The next door neighbor, through a legal petition, because the board had said that they thought that would probably be a better solution than having a real narrow driveway to a very small backyard parking area. That's because of that situation that's already come up. The case was not advertised as temporary use, it was advertised as a variance. So there's the possibility, it would have to be advertised again because the arguments are going to be different, the concerns are going to be different, the situation's going to be a little bit different, and legally it can't be heard tonight. It could be heard at the next meeting.
No,
I just kind of wanted to clarify that I was denied because I don't have access for each car to the actual road. But these cars, the current people that are in my house right now, are actually, there's one in the garage and one on the driveway. So, and I just wanted to know that or let you know that I do understand that there's a congestion problem that you're concerned with. And I think that that's actually the true problem too, is it seems like there's a concern that needs to be brought up with, I don't know if it's the developers, that there is congested parking, because like what was stated is that you could have a family that has more than 3 cars. So I'm just saying that that's just something that it seems like this is something that may need to be brought up again just with the developers, because this is, this is not just a rental thing. But I just wanted to just let you guys know, because I know that it's very concerning to you guys, and I don't blame you, that they're not in anyone's driveway. It's just they don't, according to the law, that there should have access to the road, and right now, one is in the garage and one is in the driveway. So just wanted you guys to know that. Apologize for any inconvenience also. Thank you.
Thank you. At this point, we will close any discussion from the floor, and we'll hear a motion on this possible variance.
I move we grant a variance in case number 06-03V, Zone R3, located at 30 Westfield Place. Cecilia Hanson is the appellant. Appellant is requesting variances from section 23.11, table B, off-street parking requirements, to permit conversion of a single-family attached dwelling unit to rental purposes for 3 unrelated persons.
Hold on just a minute. Is it for 3 or 2?
2.
It's 2 now, right?
The original application that was in your packet is what the appeal was based on. The request at that time was for 3 unrelated persons or a housekeeping unit. Ms. Hanson has proposed in her letter addressing the circumstances that she would rent to only 2. So I think in this case it would be 2 instead of 3, although just so you know, it was originally advertised as 3 because that's what the original refusal was based on.
So delete the requirements that I remarked about earlier. Requirements to permit conversion of a single-family attached dwelling unit to rental purposes for 2 unrelated persons where 2 parking spaces exist and a minimum of 2 or 1 per permitted occupant is required. And section 23.08.01A to permit access to only 1 parking space or access to all parking spaces is required.
I'll second.
Do you want to discuss this at all before, or do you want to
Now,
just
if
go
we're going to
through?
grant a temporary permit, or consider a temporary one at our next meeting.
Yeah, we can't do it now, yeah.
Okay, so let's go through the findings. Would you like to speak to the practical difficulty and undue hardship of this possible variance? Are there circumstances that warrant a variance?
There is no really any hardship except for the financial.
She wants to move away for a while and then come back.
Okay, but there's nothing in the property or its actual use that creates a hardship?
No.
Okay. Exceptional circumstances. There are exceptional or extraordinary circumstances or conditions applying to the property in question or to the intended use of the property that do not apply generally to other properties or classes or uses in the same zone.
No.
Preservation of equal property rights. Literal interpretation would deprive the appellant of rights commonly enjoyed by others, while granting a requested variance will not confer on the applicant any special privilege that is denied to others.
No again.
Minimum variance. The variance granted is the minimum variance required to make possible the reasonable use of the property.
No.
Absence of detriment. Authorizing of such a variance will not be a substantial detriment to adjacent property and will not materially impair the purpose of the zoning code or the public interest.
Yes.
It will be some detriment to the neighborhood, I guess.
Yes.
Apparently, they will testify to that. Number 6 is not of a general nature. The condition or situation of the specific piece of property or the intended use of said property for which the variance is sought is not of so general or recurrent a nature as to make reasonably practical the formulation of a general regulation. And that has been spoken to, I believe, by Ms. Bishop and by Mr. Pearson. So what do you think?
No.
Yes, no, it's the first one, but
Could be.
Okay. So you ready to vote?
Nope.
no.
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 No. So the variance has not been granted, and I think that you and Mr. Pearson may have some further discussion to do about what your next move will be. Okay? The next case is 0604B. It's at 181 West State Street. J.C. Snedeker is the appellant, and he is requesting a variance from Section 2311, Table A, Schedule of Bulk Controls that permits construction of a single-family dwelling unit with a front yard setback of 2 feet, where 25 is a permitted minimum, and a rear yard setback of 16 feet, where 30 feet is a permitted minimum.
This same lot in question, the board heard a request at the last meeting, and it was denied. You have a new drawing that shows a new footprint of a house that's different than the one that was proposed at the last meeting. That new footprint did not require a variance for maximum lot coverage. As a matter of fact, the proposed footprint of 628 square feet is a coverage of only 23% of this very small lot. On the new drawing that you have, what this came from was Mr. Snedeker, who is the son of the owner, went to Keith Andrews at the Metropolitan Housing Authority and got a set of plans for the exact same house that was built next door by the Housing Authority. And additionally, another house just like it right down the street and one behind it on West Washington Street. So this would, if constructed, be the fourth house of the same type of construction. One difference that Mr. Snedeker did was he knocked the porch off the back to try to help with the rear setback problem. He's 16 feet from the property line in the rear. Additionally, the drawing that you have with this proposal, what Mr. Snedeker and I did was essentially take the footprint of the house that Metropolitan Housing built and positioned it on the lot to try to minimize everything as much as possible. But what I would like to say is to indicate that on this drawing, you can see a footprint of another building. At the time the house was constructed next door by the Metropolitan Housing Authority, the old house at 181 West State was still there. It hadn't been hit by the car, knocked off its foundation, and this was before it was demolished. The house was demolished. As you can see from that footprint, the house actually did encroach into the right-of-way. The house that was there before. I think it was described as a quaint house by someone at the last meeting. And I have a footprint of the old house. It was a larger house, 669 square feet of footprint as opposed to the proposed 628. Mr. Goldsey had asked at the last meeting how close the other house would be compared to the one next door, and I actually spoke without really remembering the situation, because I suppose some would wonder by looking at this drawing, how was the Housing Authority able to build a house in the front setback without a variance? The reason that they was because this house did exist at that time, and a house down the street did exist. The zoning code says that if you're building between two improved lots where the front setback is non-compliant, you can build as close to the street as the house that's the least non-conforming. So that was the case, and that's why the Housing Authority was issued a permit without a variance to get their house that close. In the meantime, the existence of the old Snedeker house actually helped the Housing Authority. In this case, there's no one up the hill. There's nobody to put Mr. Snedeker between. So to kind of answer, to really more clarify the question you'd asked Mr. Goldsey at the last meeting, and relate it to this proposed house, it will be exactly the same distance off the street, actually 2 feet further back than the house next door. There's a in the packet of information I gave you, there's a very large and unusual right-of-way on West State Street. I think it's 70 feet wide. So, there's probably only 28 feet of pavement, because there's parking and two-way traffic. If you've gone up and down that hill, it's a little hard to pass with the parking too. So there's an unusually large amount of grassy area between the traveled surface of the road, the curb line, and the actual property line. So that's why there's this large area. If you're wondering, is it going to be real close to the street? No, it's not going to be real close to the street. As a matter of fact, if you look at the house that the Housing Authority built, I'm not sure what the scale is on this. If setback was measured from the curb line, that house is much further back than 25 feet. So it's a relationship between the property line, which is actually shared with the public right-of-way. And in some cases, those right-of-ways are very narrow. Like in the case of Westfield, I think it's 40 feet. In the case of West State Street, it's 70 feet. I think, again, as I mentioned, Mr. Snedeker, the request last time was for lot coverage variance. There's not a request for it this time. It's not going to go any closer to the street than the adjoining house right next door. And by removing the porch off the back, he's done the best that he can to maintain as much open space at the rear as possible. And just one other thing I'd like to say, hopefully in the packet of information you got, Mr. Stephen Jenkins has been permitted by Mr. Snedeker to speak on his behalf. Since the last meeting, his Air Force unit's been activated. He's on the way of going to Iraq right now. So Mr. Jenkins is here tonight to speak if you have any questions.
You got questions of Ms. Pearson? Okay, thank you. So, Mr. Jenkins, just state, were you sworn in?
Yes.
Okay, and just state your name and address, please.
Stephen Jenkins, my address is 36 West First Street, Plains. I'd like to apologize for JC not being able to be here. I'm just asking that the variance be approved. Like he said, it's the same size as the house next door, actually smaller. If you have any questions.
Questions, anybody?
Thank you.
Thank you.
Previous one was 17,
Is anybody who
right,
wishes to
and
speak in favor of this variance?
This one is narrower,
Yeah,
conservative.
yeah.
Paul Wiles from Mary Street. In favor of this in general. I think this is a good use of the property. It's a smaller request than last time, obviously in both footprint as well as lot coverage. In fact, they dropped one variance out. I noticed also one bedroom has been dropped out of the mix as well. I worry about getting hit by another car, and I haven't heard anything about trying to widen West State Street at this time, but you never can tell since it is a traffic problem. As you've gone up and down, you know you have to kind of juggle. But other than that, and as somebody, I'm sympathetic because my lot basically is 50 feet deep and 100 feet wide. So if I ever had my house burned down, I'd have the same problem. Thanks.
Thank you. Anybody else who wishes to speak in favor or general comment?
I have a question, really.
Yes, and you've not been sworn in, and so do you affirm that you will tell us the truth?
I do.
Thank you. So state your name and address, please.
My name is John Thorndike. My address is 13034 McDougall Road in Athens. And I own a house on West Washington, which is just down the alley. I'm one house away. Above me is a house that used to be owned by the Procos family. I'm not sure what state that's in now. I know it's not rented, and something will probably happen to that house. So I'm actually not right next to this house, but my concern is that although this is a West State Street address, there's really no access to that alleyway, no effective address from West State. No one ever goes over that. It's too steep. It's just an extreme drop. And I'm not even sure what I'm asking here, or I'd like to point out that I'm sure that the access to this, I'm assuming, would come off of West Washington, and that's an extremely narrow alleyway, which does go about 5 feet from the house that I own there. And can you tell me what the plan is on access? I see there's supposed to be a garage in the back. I cannot.
On access, there'll be 2 parking in the rear, which you will have to go down that street, and the basement will be 2 parking. So you'll just come in behind the house, and 2 will park underneath, and then 1 up front. So they will have to use that street.
They'll be using the alleyway.
Yeah.
So they'll be coming off of Washington?
Yeah, they'll be coming off of Washington onto the alley and then around to the back of the house.
Right.
And they'll be parking for 2 cars underneath.
I'm not sure what to say, except I don't like it. But I mean, I actually don't mean to speak against the project, basically, but I am concerned about that. I don't know if there's anything that could be done about having access. You know, it's a West State Street address. Can there be some access off of West State so that the alleyway is not used? It's really a tiny alleyway, and that would be a couple of houses that would be using that.
There'll be enough room in the front to park for 1 car in the right of way, which right now I have seen cars park in. I don't know whose car they are, but somebody does come in and park in the front yard. But that's the only way to get access to the rear is that alleyway, because there wouldn't be enough on either side of the house to have parking for the rear.
Right. Again, I would like to come with a definitive opinion, but I don't really have one. It's just a question of that is a very tight use of that alleyway.
Thank you.
I don't know what else to say.
Thank you. Anybody else who wishes to speak in opposition?
The issue of accessing property is under the exclusive jurisdiction of the Service Safety Director. There are opening permits / curb cuts reviewed and approved by the administration all the time. As a matter of fact, right down the street, the two housing authority houses that are back to back are situated exactly on the same type of narrow 10-foot wide alley. Both those properties park behind the structure. They don't have their own driveways. So they use the next alley down to access parking in the rear. I talked to Mr. Snedeker about how he'd like to get to the parking. I mean, it would be kind of nice if he had an option to come in further down the street and have a driveway that came in off State, came all the way around and went out to the alley. But again, until that's reviewed, an application is received for that, the Service Safety Director he's the one that acts on those. The house right next door, it's hard to get in and out of that driveway, but the city recently went through a pretty long, lengthy, and very costly, in the end, situation related to access to properties at the Dairy Queen site. And even though they even had multiple access points, the city was not permitted to keep them from using even a third or a fourth access point. So just so you know, administratively, we always look at the entire condition. We try to make decisions that are the safest, have the public interest in mind, but also permit private property owners to exercise their right to use the property in a reasonable manner. So that's hopefully a little question to the access.
Parking is allowed on East State Street there in that area, isn't it?
On East State, on West State.
On West, I'm sorry.
There are, trying to remember as you're climbing the hill. As I'm climbing the hill, probably just at where Arts West property ends, there's no parking up at that end, and then parking is permitted down quite a lengthy bit of that street. And I believe there is parking permitted on the high side or the north side of the street, right there. And again, the house next door, it would have been nice if there was a different way to access that property than to have a driveway that came right out there with parking, fairly narrow street, fairly steep, quite a bit of traffic. But in that particular case, there was no other option. In the case, as I mentioned, right down the street, same type houses, same alley situation, no additional driveway was permitted to access either Washington or State. The access was in off the alley. So if we follow that example, more than likely, if Mr. Snedeker asked for a driveway onto West State Street, he'd be denied because he had a reasonable access in a safer place off the alley. Now, as I mentioned at the last meeting, the condition of that alley is something that the street department has to look at. Do they have dollars to maintain or upgrade or improve existing streets? That's always,
Would that have to be improved before it could be utilized?
It's in an improved condition right now. It's in the public inventory of streets. It's just like any other street that might be.
So it can be utilized at this point in time.
Right. It's an area dedicated to public use and improved to, not the greatest standard, but not much more than a step above mud. But
it'd be accessible.
It is a permitted public access point to the property.
And could I just clarify, how many parking spaces are we talking about on this property?
Depending on how long the driveway is, for example, if you had that loop driveway, you could probably park 6 cars. That would include 2 underneath in the basement area.
Right.
That's one difference. The previous one that you heard had a garage that came in right off the alley. Mm-hmm. In this case, Mr. Snedeker, moving the house further to the street, had the opportunity to put the driveway and the parking in off the rear, rather than have it come right straight off, off that side alley.
So there's going to be parking in the rear and underneath, is that correct?
Right.
Okay.
And just again, to kind of reiterate what I said in the first case, parking, the configuration of parking as zone-driven and not use-driven. Now, this is the same type of use, but in R1 and R2 zones, you can have just a long driveway and every car, the first car traps the other two in, or the other 3 or 4, or however long your driveway is. So Mr. Snedeker was hoping, that this would, the building is the only thing that's considered in the setback, not pavement or parking or anything like that. The only thing that the code says is that you can't establish an area for parking within 12 feet of a residential structure on the adjoining lot. So this will be much further away than that 10-foot minimum that's required.
I have a question. If we grant this variance, will that limit whoever utilizes it to constructing a house that's the same dimensions as what we're being presented with?
We can put that into a...
Well, I'm just wondering if this...
Someone could take this and build an even smaller house with less encroachment.
Exactly. But not larger.
But no, not larger.
And
not
they
larger
can't
at all.
move it around. The minimum setback
what
would be...
we advertise for certain setbacks, it has to be in that footprint of that building or smaller than that. In times past, a lot of times when the board had concerns about such things as that, I've noticed that historically they used to say, and in substantial compliance with the plans as presented, or in substantial conformance with the plans as submitted. So you could tag that statement on or amend your motion to say, in substantial conformance with the plans as submitted, if you had some doubts about, could it move around, would it move around?
Thank you. Let's see if Mr. Jenkins wants to say anything else. Okay, then we'll close the floor and have some discussion. Do you want to make comments before we hear the findings? I guess that means no. Okay. Practical difficulty and undue hardship.
We haven't made a motion yet.
Oh, I'm sorry. Go right ahead and make a motion, please, and add that statement to it.
You want to make the motion with the amendment that mentioned, Roger?
You want me to?
Yeah, since you suggested the amendment.
Okay. I move that we grant a variance in case number 0604V 18 West State Street, Zone R1. 181, I'm sorry. West State Street, Zone R1. J.C. Snedeker, appellant. Appellant is requesting a variance from Section 2311, Table A, Schedule of Bulk Controls, to permit construction of a single-family dwelling unit with a front yard setback of 2 foot, where 25 feet is the permitted minimum, and a rear yard setback of 16 feet, where 30 feet is the permitted minimum. And if we would grant this variance, it would be in substantial form of plans presented.
Compliance with the plan.
Substantial conformance of the plans that are being presented.
Second.
That will also assure that stay at 3 bedrooms.
Okay. So let's look at the findings. Number 1 is practical difficulty and undue hardship because of exceptional or extraordinary circumstances or conditions pertaining to a specific piece of property. The literal enforcement of these regulations will result in practical difficulty or undue hardship that is unnecessary to the achievement of public purposes.
We said last time the lot is extremely small.
Yes, and curious shape, and drops down the hill and so forth. Okay, exceptional circumstances. They are exceptional or extraordinary circumstances or conditions applying to the property in question or to the intended use of the property that do not apply generally to other properties or classes or uses in the same zone.
It's a relatively small lot.
And
This is actually one of the smallest lots in the plan.
It is, even though there are some other small ones there, it does seem to be really about the smallest. Preservation of equal property rights. Literal interpretation of the regulations would deprive the appellant of rights commonly enjoyed by others in the same zone and the same vicinity, while granting of the requested variance will not confer on the appellant any special privilege that's denied to others.
No problem there.
Okay. Minimum variance. The variance granted is the minimum variance required to make possible the reasonable use of the property.
Pretty minimal.
Yes, it's difficult to put a house on this lot, and so this...
And 24 by 24 is pretty small footprint.
I think we established last time that you needed a variance for the setback.
Yes, exactly. And we did mention last time that we hoped that the property, the building would be about the same size as the old house, and now it appears that it's going to be a bit smaller. Okay. Did we do absence of judgment?
No.
Thank you. Authorizing of such a variance will not be of substantial detriment to adjacent property and will not materially impair the purposes of the zoning code or the public interest.
I would think so.
Okay. Not of a general nature, the condition or situation of the specific property or its use is not of so general or recurrent a nature as to make reasonably practicable the formulation of a general regulation for such condition or situation.
No, because being such a small lot.
How come last time we said yes to that question?
We did.
Said yes, it's not of a general nature.
Yes,
It's kind of like a yes, no. A yes, no.
Okay, so you ready to vote? We'll start at the end with Mr. Sheffield.
I vote yes.
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 I'll vote yes as well. So, Mr. Jennings, you can tell your friend that he has the variance, and I believe you need to speak to the code office about taking care of that. Okay, now we are ready to hear case 0605B, which is 316 Carroll Road. The appellant is Don Linder. He is asking for a variance from Section 2311, Table A, Schedule of Bulk Controls, to permit construction of a single-family dwelling unit with a front yard setback of 17 feet, where 25 feet is the permitted minimum. So, Mr. Pearson, do you want to address that?
There's quite an extensive packet of information and quite a bit of governmental documentation related to this particular area. The original owner of the larger parcel of land sold a section of it to Mr. David Sturbois several years ago. He had to subdivide it, have it annexed into the city. There's a lot of documentation related to that in the packet. And the property drops off very steeply when you go back not too great a distance off the paved surface of the road. There's documentation that when the Planning Commission looked at that, they essentially said they didn't have any problem with the zoning board granting any variances if requested for setback. And actually, in case number 9917B, 312 Carroll Road, David Sturbois appellant, the board did grant a variance for construction of a single-family dwelling with a front setback of no less than 18 feet. Now, that particular structure was built and is there right now. However, Mr. Sturbois, for some unknown reason, didn't essentially cash in his variance and build his house closer to the street. It actually meets the front setback requirement as it was constructed. So there's a case where a variance was granted, but it wasn't utilized for whatever reason.
Well, he didn't need to, and it certainly looks better being lined up with the others.
There's currently construction of another single-family residence fairly close by right now. It's the distance that it is off the road is based on a different type of site development technique than Mr. Linder wants to use, and I think I'll let him probably in more detail describe that. When you have these lots that are kind of shallow that drop off severely because of their shallowness, the lot itself is very deep and goes way back into the woods. There are several different structural techniques or designs that you can use to accommodate the siding of the house. A lot of times people bring in lots of fill and just fill the lot up. Mr. Linder's proposing, and he'll give you more detail on it, a different type of technique where he's just building a retaining wall in the back, and essentially the fill will only go up to the retaining wall, so you don't have all that new soil and earth disturbing activity going on to build the site up. So he's just approaching the situation a little differently than some in the area have done. But again, it's just a construction, it's a design structural technique.
Have you issued any kind of a permit already because it looks like the wall is back there has been already built?
No permit has been issued for any type of construction.
So what is that wall back there then? There's some people activities going on.
I've stated this a couple of times at recent tree commission meetings, and I have at the board too, that whenever, and I won't name a particular person or particular building, but someone came to the board several years ago asking for a parking variance. And their building was actually under construction. The plans approved by the State of Ohio Department of Construction Compliance, who has building permit jurisdiction. The city is a zoning department. We have a zoning department, not a building department. We issue zoning certificates, not building permits. I requested the law director's office to prosecute this individual for starting construction without a zoning permit. And there was consideration for the parking, 2 or 3 different appearances before the board. When I finally got to municipal court, the municipal court judge was convinced by this person's attorney that zoning had to do with use and didn't have to do with building. The proper building permits had been obtained, and therefore there was no violation of a building code. The zoning code having to do with use could not be violated until there was actually use of the property. So at the time, our local municipal court judge said that we had improperly filed charges against this particular individual. So to answer your question, until the house would actually, a key would be turned over and the building be occupied, there's no violation, according to our municipal court decision several years ago. So you can go out there and do just about anything you want at your own risk.
So you can actually go out and start a house and build it, assuming you're not violating any setbacks or anything?
You just can't, you can build it, but nobody's allowed to live in it.
Right. Interesting.
Yeah, it is interesting.
Thank you very much.
It took a while, and that was tough going to court for that one, but.
It took me 9 years to figure it out.
Okay, so now maybe we can hear from Mr. Linder. And will you state your name and address?
Thank you. Don Linder, 161 Old Coach Road. 163 Old Coach Road. I always forget that. We've moved enough up in that neighborhood. I'd like to maybe just make a quick comment that we're actually not building a house up there now. We're building a retaining wall. And I'm not sure if there's any provisions in the code that address that issue. First of all, obviously I think the package speaks for itself, and I guess I'm here for clarification than anything else. Certainly, as I did due diligence on the purchase of that property, I had gone back into the records and dug up information which would imply that there certainly would be a good chance to be able to achieve a variance on this property when the planning board, the planning commission granted a statement that indicated, in fact, I'll quote, and this is regarding the 4 lots that were annexed into the city by Mr. Sturbois. That is the planning commission's intent to request that if such a variance is requested for setback requirements from the developer or a future property owner, that the zoning board would grant the variance due to the planning commission's action on this case. Obviously, when I'm looking at this, I'm thinking, well, gosh, that's a pretty good chance that if I came in front of the Board of Zoning Appeals, I might be granted a variance. One other comment, which is part of the packet, which is a plat of variance. And I'd like to ask you to refer to that for a moment. And this was done by my surveyor and engineering firm, which indicates really the exact location of what I'm proposing as the residence. And as you can see, relative to the newer residence on the left-hand side, which is 312 Carroll Road, the Mumfors residence, that the left side of my proposed residence, in fact, does line up with their residence for a period of a space of, well, I don't know the exact dimension, but that corner lines up with the corner of their house approximately, more or less.
It's 8 foot further out.
And that the center section of the house bumps forward approximately.
This is when he got permission to set it up and didn't.
Right.
So it's actually a foot further back.
But you can actually see that their house sits back further than the setback requirement, which is the dotted line. And so my left-hand side of my house, my proposed house, would be pretty much right at that dotted line, or the setback requirement. And then in the middle section of the proposed residence is where there's a bump out of approximately 4 feet. So the center section of the house bumps out that amount, and then the garage section is really where I'm asking for the full 8-foot amount. And that sits so far from the older residence to the right-hand side, approximately 70 feet, that in fact, it's my opinion, this really has little to no impact, because there's enough green space and terrain change there that, albeit, yes, it will stick forward of that, it's going to have little to no impact on the neighbors, period, in my opinion, based on the requirements of your decisions here. And obviously, we had some discussion with both the older resident neighbor, and that was Derek Mason. And his concern is whether we were going to be able to build a house of equal value to the others in the neighborhood. He was afraid that, oh gosh, we might put a double wide in it or something else. And I assured him that our residence was going to be of equal value to the neighborhood, and in fact enhance that lot in that area with value. And then the same with the Mumpers to the left of the house. They had similar concerns of both value and where was the house going to sit. And I spoke to Mr. and Mrs. Mumford 2 days ago, and I said that if you did have concerns, certainly you're welcome to address those here tonight. And I don't see her here tonight, so I would imagine that if she has objections, she's certainly not airing that. Certainly the circumstances from the standpoint of construction, and the reason why I'm building a retaining wall there is because I think I'm following good construction techniques. We both put a retaining wall in to resist any possible movement of the soil, and also create a backyard, albeit small, for the residents that we're proposing to build. Also, it's pretty much common knowledge in the building industry that you prefer not to build on fill. I mean, that's just preference. And
Has there been any fill back there at all? It looked
yes,
like, okay.
There was. In fact, Mr. Sturbois, back in 1999, I believe, when they built the house next door, wasted some of the soil on my site.
Okay.
So there is a little bit of fill there. We did some test holes and found out where it was, how much it was, and of course that
It
played a
appears to
role.
be quite a bit, but I don't know.
Right, it's probably 100 tons,
Yeah.
at least. So we're trying to really stay to where the rear of the foundation of the house does not go over the steep part of the hill. Again, in my opinion, a good construction practice. And then relating to a letter that Mr. Bob Mulligan reviewed the soil types in those 4 lot areas. Of course, he was specific to, I think it was lot or house 312, it might have been 306 actually, but really those soils of similar type. And he made a comment in his letter, which I think goes across all lines of a good construction practices. I would also discourage any unnecessary excavation on steeper slopes. And from a soil scientist or soil engineering perspective, you don't want to put a building on a steep slope if you can avoid it. So again, I'm trying to follow good construction practices to avoid that. Just one general comment, as probably a few of you know, I had been an independent building inspector in the city of Athens for 25 years, inspected over 4,000 homes, and I have probably inspected hundreds of homes that have been built on fill and in proper situations, and they have reoccurring foundation problems. And as dedicated builder to this region, I don't really want to participate in building houses in substandard sort of conditions. And I guess the rest kind of speaks for itself, and if you have any questions of me, I'd be glad to answer.
Had you considered putting a narrower house on there at all in order to not have so much sticking out?
It is. Narrow in depth or narrow?
In depth.
It is. I believe that's why we have
What
an
is your total depth?
34 feet or 36, I think. It's, in fact, we changed the house design to try to squeeze it in better. Actually, it's on the house plan.
Looking at your filed variance, the houses next door don't appear to be nearly as deep.
They are.
Is that an illusion?
Is this drawing to scale?
Yeah, that is the scale, but that's just really showing the front part of that.
I got some pictures if you want to look at of their neighbors' houses.
But we
The,
can't tell, since they don't have a house yet.
The total depth of the
Neighbor's
house
on the
Yeah.
sides.
is 27, 31, 35 feet, which is really not that deep of a house. That includes the garage bump outs in the front. And of course, we're building a house that basically blends and accommodates what is in the neighborhood. It's a 4-bedroom, 2.5-bath house.
I'm still not clear, why does it appear so much larger on the platting diagram than the?
Yeah, that's a
than
good
312?
question. I think what they were doing, what they did, frankly, is just draw in the main portion of the house, and as a reflection of what the front setback was. They didn't measure the rear of the house. They just measured the front of the house.
Okay, so that's more of an icon.
Footprint of the two buildings on either side are nowhere near to scale.
Right. That's yeah. But I think what they're doing is just reflecting the front of the house. Right. That's a good point, and I asked the same question of myself.
So this scale, and it shows that
The scale of my house
the
is,
proposed building will stick out 8 foot further than any of the adjoining homes, is that right?
yeah, any of, to the one to the left, approximately, yes.
In the briefing materials, it said that the variance granted for 312 was for 18 feet, or
Right.
18 foot setback, and yours is a 17 foot.
That's right. 1
So-
foot, I'm asking to come,
Yeah.
in a sense, 1 foot forward than what was requested before.
I mean, did you
That was
think,
just a request, that was
Yeah.
not a construction.
Right.
okay.
That's correct.
So,
Is that confused? Are you
well, I guess
confused?
what I'm wondering is, would it have been, I mean, did you think about lining up with the old request first?
Right.
And then, and what were the problems associated with that
Well, the
idea?
steepness of the hill, I would be 8 feet over the edge of the hill, which drops off 20 feet in that 8 feet. So in 8 feet over the hill, if I went over back 8 more feet, it would be, well, I wouldn't say quite 20 feet, but significant, to be able to get down to where I can actually put a footer in. Where my retaining wall is now is what, in my belief, is the stable soil, which is approximately 20 feet, from 20 feet to the footer to the top of the hill distance. And it'd just be infeasible to have a 20-foot or so foundation wall on a residential house.
Now, how far is going to be the back of the house to the retaining wall?
Probably about 20 feet,
So why can't you move it backward, closer to the retaining wall?
because that's where it drops off so steep. It's just
The
an
retaining
unstable.
wall is the
retaining wall-
retaining wall on substantial soil? You're saying you
That's
set
right.
the well,
Right,
well,
that's
then
correct.
everything in front of that retaining wall apparently is
But the height
substantial
difference
soil.
is so great, it's 20 feet, so I would have a 20-foot tall basement.
There's several of them now.
I don't know of
One
any
up
up
in
there.
Oakmont that Tony Farron put in.
It doesn't have a
On the
20-foot
right.
basement. It's just an 8-foot basement.
So I was under the impression that the back of the house would be just close to that retaining wall and seems to be doable.
Well, it's going to be probably within 20 feet. certainly we want to be able to have a backyard for somebody or be able
You
to have a
have
deck.
so much backyard in there, you know, you can go down, take a steps and use the backyard.
Yeah.
Other questions or comments from the board at this point? Okay, thank you. You'll get a chance to come back up.
Sure.
Anybody who wishes to speak in favor of this variance? Anybody in general comment? Anybody in opposition? Not general comment?
I'm
Okay.
totally neutral.
Okay.
I promise I'll always be neutral from here on out. I was up at the site today to look at the situation and did have the discussion with Mr. Linder, even though we didn't have this particular drawing and I didn't remember it, what this illustrates. The area right here next to the residence next door, that corner basically lines up with that house next door. The trouble with the zoning code is it talks about any member of a structure that's encroaching. So it's not the whole front of the building that's encroaching, just a very small portion of the living area actually is. An attached garage falls under the same setback requirements as a principal structure. If the garage is attached, you look at the whole thing. A garage, if it's split off separately, can actually be pushed as close as 5 feet. You can't go in the front setback, but you can go as close as 5 feet to a property, an adjacent property on the side or on a rear property line. The distance and just kind of acts to talk about it again. It's kind of like a little ravine that drops off in between. It's quite a distance from this side of the house to the house next door. And again, it's just the garage portion that's sticking way out there. Just a small portion of the living area is indicated by this drawing is actually in the setback. But again, the code doesn't differentiate between, if part of the structure steps out and the other part steps way back, but I just did want to point that out.
Anybody in opposition? In that case, Mr. Linder, final comments?
Yeah, I think just a clarification comment. I know the question was asked, well, why don't you build the foundation where you're building the retaining wall? I don't believe that's good construction practice because, one, I did not obtain soil information on that, and certainly that's not required for a retaining wall. And certainly that is my risk to have built that retaining wall.
Well, that's the difference of opinion. I think it's okay. I built a few buildings, but
right.
That's just it.
Sure, understood.
Yeah.
And respect your opinion on that. Okay, thank you.
In that case, we'll close the discussion from the floor and see what you all have to say before we approach the findings, comments. No comments?
It's too bad that it couldn't be modified to some extent so it wouldn't stick out 8 foot further than any of the other houses there. It's an extremely deep floor plan.
Well, that'll show up, I think, in our findings.
Mr. John's observation that retaining wall in the back certainly has some significance with regard to possibilities of, there's lots and lots of homes with steep backyards. Maybe some of us even live.
Well, let's address the findings. One, practical.
We make a motion, maybe?
Oh,
Okay, I'll go on with-
I'm sorry, I keep forgetting the motions.
I move to grant a variance to the property on 316 Carroll Road from section 2311, table A, the schedule of bulk controls to permit construction of a single-family dwelling unit with a front yard setback of 17 feet where 25 feet is the permitted minimum.
second?
Second.
Okay. Okay. So, number one, practical difficulty and undue hardship because of exceptional or extraordinary circumstances or conditions pertaining to a specific piece of property. A literal enforcement of these regulations will result in practical difficulty or undue hardship that is unnecessary to the achievement of public purposes.
Well, you could argue that a smaller building probably could be utilized, you know.
Try to put a
Would be a minimum
size
variance.
10 foot and a size 8 tree.
Yeah. And I think a lot of lots have been filled there that I saw. Had backyards filled, so I don't think it's that big a hardship to fill it.
Exceptional circumstances, there are exceptional or extraordinary circumstances or conditions applying to the property in question or to the intended use of the property that do not apply generally to other properties or classes or uses in the same zone.
And most of those properties have that same kind of backyard.
There, you see that one down there in Oakmont, down there in that circle when it's
So,
out there?
It's
It's
pretty much the
really
same.
over there.
There are a lot of steep slopes in that neighborhood.
Yeah, in fact, the next door house has the same problem, steep going
They
down.
put a retaining wall back
Yeah.
there, stone retaining wall.
Preservation of equal property rights, literal interpretation would deprive the appellant of rights commonly enjoyed by others in the same zone, in the same vicinity, while a granting of the requested variance will not confer on the applicant any special privilege that is denied to other properties in the same zone.
Sticking out that close to the road would certainly be a special.
Yeah, compared to the other houses along there, how they line up.
So you're not concerned too much with the fact that the city council has suggested that...
It was just a recommendation.
Okay, and we've ignored them before.
That's
so-
your right. That's what our job is.
Okay, just wanted to remind you of that. They had granted sort of certain privileges to this neighborhood when it was put in. Minimum variance. The variance granted is the minimum variance required to make possible the reasonable use of the property.
Mhm.
So what are you saying?
Well, the property could be developed or utilized without any variance, so this is not minimal.
Okay. Absence of detriment. The authorizing of such variance will not be a substantial detriment to adjacent property and will not materially impair the purpose of the zoning code or the public interest.
Purpose of the zoning code in some degree was to line homes up and not have them.
That is true, but in this case, some previous consideration, it was already given to this whole area when they made...
That was an assumption on their part.
Okay, all right. And you are suggesting that it would be detrimental to adjacent properties to have something sticking out in front of them, is that your...
It must be, I mean, it's the code everywhere all over the town.
Okay. Not of a general nature, the condition or situation of the specific piece of property or the intended use for which the variance is sought is not of so general or recurrent a nature as to make reasonably practical the formulation of a general regulation for such condition or situation.
It's not general, I guess.
Yes, we're certainly probably not going to ask the city to
Change the law.
change the law to accommodate this. They have already sort of addressed the situation up there and made a suggestion, which we are not bound by, but they have made it. Okay, anything else you want to say before we vote?
Nope.
Okay, let's start with you, Greg.
I vote no.
Roger?
No.
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 Well, I guess I'll vote no, too. Okay, so I guess that's not going to be built exactly as planned, maybe something else smaller in the front.
There's no ability to have general comment after the vote.
People have said things to us before, but we probably know how you
We've
feel.
even been called racist once,
Yes,
weren't
that's
we?
true, yeah. Okay, we have one remaining case, and it is case 0607B. It's 13 Lawson's Way, and the appellant is Tom Lovedahl. who is requesting a variance from Section 2311, Table A, Schedule of Bulk Controls to permit the addition of a front porch to a single-family residential structure with a front yard setback of 21.41 feet, where 25 feet is the permitted minimum. Okay, Mr. Pearson.
Where this residence is located is in a subdivision called Blackburn Woods, which the developer is Mr. Tom Lovedahl, and he's currently the owner of all the lots in the subdivision. This is the first house being constructed in the area, so there's no neighbors there. Included in the packet of information that you had was a plat, copy of the plat of the subdivision, clearly indicating the 25-foot setback line on the plat. So not only is the right-of-way indicated, but the building setback line is on it. Also included in the packet of information is the footprint of the building for the approved plans that were submitted to my office. It shows a porch on the front, and a copy of the permit that I did approve to start the construction, which indicates that the front yard, the front setback is 25 feet. This is kind of the same situation as the last case. You can see from the plat that was for the illustration that was generated. It is called Plat of Survey by George Seymour. It illustrates the portion that's encroaching in the 25 feet. Mr. Lovedahl probably can explain better than I how it was determined where the initial excavation for the basement was going to take place. I'm sure if he knew he just needed to move back just a few feet, that would have happened with that initial excavation for the basement. But what was discovered when they actually went to build the porch on the front, that there was this small encroachment into the setback area. There's quite a bit of pavement on cul-de-sacs. The city requires a 50-foot radius on the right-of-way area. The fire chief requires an 80-foot paved area, or 40-foot radius, 80 feet of pavement across a cul-de-sac. So the city of Athens is probably one of the few places around where you can land a jet on the end of some of these cul-de-sacs. They're huge. So there's only 10 feet of grass behind the curb line. That's in the public right-of-way. This is a dead-end cul-de-sac, and no other houses have been constructed there. Besides that, unless you have some questions.
Questions? Okay, thank you very much.
When he's talking, can you pass that diagram down here?
Sure.
So we can look at it?
What I had done was I had mailed this information to everyone. Had emailed everyone too that it might potentially be on the agenda as a fifth case. It's actually on as the fourth case tonight because 150 Grosvenor was dropped.
Okay. Mr. Lovedahl, and I don't believe you've been sworn in, have you?
No, I haven't.
Okay. So do you affirm that you will tell us the truth?
I do.
Thank you. And please state your name and address.
My name is Tom Lovedahl. I'm the developer of Blackburn Woods subdivision and also the builder of the house at 13 Larson's Way. And I guess in many ways I find myself astounded to be here tonight, having gone through several years of review to get the subdivision approved, constructed without a variance, and then have to ask for a variance for the simple porch on the house. I don't really have a good explanation as to how we missed this particular setback. We did have surveyors come in and they pinned the corners and lines for us. We thought we had the house substantially set back so that the porch would not encroach in the 25-foot required setback. Part of it may be due to just the confusion of the general construction there. A couple of our monuments were upset during the construction, and we thought we had reconstructed them properly, but obviously missed by a couple of feet. We looked at this house once we realized we had made an error in the setback. We looked at versions of the house without the porch,
And I don't know, I think Mr. Pearson went up there this afternoon. I don't know if others of you have seen the house, but it has a rather large elevation, and to have a porch on this particular house is a key architectural detail that breaks up the facade. In addition, we have spent, literally hundreds of thousands of dollars creating this neighborhood in Athens, and we really do want it to be a true neighborhood. We have guidelines for features on the houses that are to be constructed there, and one of those is a minimum of 6 feet or a usable front porch. And we feel that this is really important for neighbors to have a place to congregate and visit, things like that. We hope that, this project will be of great benefit to the city for the years to come, and would really like to see the house built with a porch on there, and would ask for your approval of such.
What do you measure the 25 feet from the house to the curb, or what is it?
No, the actual, there is, as Mr. Pearson was stating, there is an 80-foot diameter paved area,
right,
and an additional 10-foot right-of-way, and then the 25-foot setback.
So you're actually close to 35 foot off the curb, is that correct?
Yes, 35 feet. The house is a little over 38 feet off the curb, and the porch, the dimensions that are shown here are to the overhang of the porch, not the porch itself. So the overhang is a good foot or so. So the 3.4 feet or whatever is actually reduced to 2.4 on the actual stoop.
Do you own all the lots around there? Or?
Yes, we own all the lots. The subdivision is just really being completed.
You can't make the diameter smaller, right? That sounds like at the end, make it a little
I'd like to. Would have liked to years ago, but and we have looked at the adjoining lots, and I will build the houses on those too, and they have completely different geography and topography. So we won't have one of these lineup questions where we'll have one house sticking out a few feet more than the other.
It's in a circle, so you're not going to.
It's in the circle, and they'll be set back substantially beyond 25 feet on the other two. There's also a practical issue here. I don't know, Mr. Bruiser perhaps can identify with this, but we have made it a practice to build porches and protect all our entries over the many years we've been in business. We've done quite a bit of work on older houses, and actually on one or two that we built some 15, 20 years ago, we have recurrent problems with doors that are not protected. It's almost a guaranteed homeowner's nightmare down the road, with rot, things like that. Properly flashed, properly caulked, properly installed, still problems. So we really feel it imperative to have a good porch on the house.
But no couches on the porch, right?
No couches. No.
Other questions for Mr. Buckton? You'll have a chance to come back and speak to us again at the end of this.
Okay.
Anybody who wishes to speak in favor of this variance? General comment?
Paul Waugh through Mary Street, just Paul Waugh through Mary Street. In general comment, or I guess as a former zoning board person too, I've seen this happen before. I think you have too. I'm kind of surprised that with all the work and hundreds of thousands of dollars that go into this, that the calculations of a circle or a radius can't be done well. I think you saw this on, was it Warwick or maybe, and then I think you saw it at Turtle Run one time. I think you'll keep seeing it until someday somebody has to tear a house out and start over. But that's just a general comment.
Well, happily, this isn't the house that would need to be torn down. It's just a porch that could be left off.
It's easy to do, isn't it?
Other comments in general? Comments in opposition? General comment? General comment?
Yeah, this is a real general. If you looked in the drawing, whenever a subdivision is approved and platted out, it has lot numbers on it. And what the city has to do is go back through and do address assignments, and there's a administrative process that we go through to do that. When we numbered the lots in Blackburn Woods, this particular lot came up 13 Larson's Way. And Mr. Lovedahl called me up and wanted to know if I could change it from 13 because he thought there might be some problem with it somewhere down in the future. And I ran it by the fire chief and the police chief, and they said, you know, we're not superstitious. It's going to stay 13 Larson's Way. So
And then,
it is 13.
So what are you saying now?
general
No
comment.
comment.
Okay, anybody in opposition? All right, let's close discussion and have a motion.
Whoever has the thing.
All right.
Nobody has it.
Oh, you have that.
Well, I make a motion to grant a variance in case 06-07V, 13 Larson Way, Tom Lovedahl appellant. Appellant is requesting a variance from section 23.11, table A, schedule of bulb controls to permit the addition of a front porch to a single-family residential structure with a front yard setback of 21.41 feet, where 25 feet is the permitted minimum.
Second.
Okay. Comments you want to make before we look at the findings? And I apologize for not letting you reappear. Do you have anything else you want to say before we go to the findings?
I know one of the issues in the findings
You're gonna have
is
to come up with
I know one of the key issues you talk about in the findings is the hardship component of it. And it's hard to say, you know, what the hardship is here. We obviously have hundreds of thousands of dollars at stake, and we obviously would like to have an attractive subdivision and kick this thing off on a very positive note. We don't know, you know, if the house is more or less saleable with or without the porch. We think it's definitely less saleable without the porch, just from an aesthetic standpoint. You know, we have a very plain-looking facade and what we hope to be an attractive subdivision. Thank you.
my apologies. Okay, let's get back into our right order here and look at the findings. Okay, is there practical difficulty and undue hardship? Because of exceptional or extraordinary circumstances or conditions, the literal enforcement of the regulations would result in practical difficulty or undue hardship that is unnecessary to the achievement of public purposes.
You know, go ahead.
Well, you know, that's a tough one. You could say no due to
Part of the
calculation error.
Part of the consideration, I think, is making certain that the homes are lined up, that we don't have one that's sticking
Right.
out.
There is no hardship because you don't have to have a porch.
Well, I'm not sure that I'm going to say there's desperate hardship, but I'm not going to say in this case that I would agree that lopping off the porch may be the answer. Okay. All right, so I'm not sure. What else did you want to say?
It is a financial hardship, otherwise, you know, there is no hardship for them.
Anybody else? Okay. I guess I would say here that I think there is some hardship if you have, in fact, assumed and tried to comply and put your house in the right place, and then through whatever the circumstances were to discover that inadvertently it's not in the right place. Okay, exceptional circumstances. There are exceptional or extraordinary circumstances or conditions applying to the property in question or to the intended use of the property that do not apply generally to other properties or classes in the same zone.
Does the calculation error count?
Well,
It's not
and
very special.
you could say, I mean, at the moment, this is the only house in the zone, so.
And circles are always troublesome because when you put a straight line related to a circle, your corners are way back and your center is disproportionately close, so.
Well, so you might say that the exceptional circumstance here is that, one, there are not any other houses there at the moment, and they're not going to be in a straight line, so working on a circle presents a different set of circumstances. Preservation of equal property rights. Literal interpretation would deprive the appellant of rights commonly enjoyed by others in the same zone and the same vicinity, while granting of the requested variance will not confer on the applicant any special privilege that is denied to other properties in the same zone.
Unless the other people come for a variance for their purchase, this will have has some privileges that other
Well, I think
will
you
not
must
be.
consider that Mr. Lovedoll owns all of the property there, and he intends to build all of the houses. And surely, if he came back for a variance having made the same mistake, he would not be granted it.
Then, yeah. But hopefully this will prevent the future ones to happen. So this house will always have additional privileges or granted.
Well, we're talking about 2.5, 3 feet of privilege that will
Yeah.
hardly be noticeable on a circle.
I'm just answering the question.
I think coming back to the board will be enough disincentive to check this back.
Tony Ferry hasn't been back.
Well,
We're also talking about the professional builder, who this is the first of them, probably many to come in.
Well, I remember one of the very first cases that I heard on the zoning board years ago was a house that had been completed, and then they discovered that one of the corners was in the setback. And I did think from the discussion that they were going to make the guy tear off the end of his house. I was rather appalled. Okay, minimum
And
variance.
there was also, I don't want to interrupt the thing, but there was also a steep in the back. The lot is very steep in the back. So was that a problem that you couldn't go further, or
This
didn't
one
want?
is quite steep in the back and has required fill.
So you could have gone a couple feet further back?
If we had picked up the mistake early on, we could have gone a couple feet back, yes.
But there is some configuration of the lot that you could say creates some hardship. But that's not the real mistake, is it?
No.
Okay, the variance granted is the minimum variance required to make possible the reasonable use of the property.
Not really.
We're talking about a couple of feet here.
Oh, yeah.
It's not like we're talking about a great big distance. Yeah, we're talking this much. I think that's pretty minimal
3.5,
myself.
3.6 feet.
Absence of detriment. The authorizing of such variance will not be of substantial detriment to adjacent properties. There are not any.
Yeah, all right.
And will not materially impair the purpose of the zoning code or the public interest. My own opinion would be, in this case, particularly since the houses are not going to be lined up, that there's not going to be any noticeable detriment. Not of a general nature, the condition or situation of a specific piece of property or its intended use is not of so general or recurrent a nature as to make reasonably practicable the formulation of a general regulation. Certainly that doesn't apply here. Other comments, things you want to say? In that case, let us vote, and we'll start with Mr. Gulsey.
No, I want to be the I want to wait for a little bit.
Okay,
so
then we'll
you guys
start
yeah.
with Mr. Shimpey.
I vote yes.
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 Since we have the yes, I would say no then.
Okay, and I'm going to vote yes as well, so you will have your variance, and I think you know how to proceed from there.
Just don't let it happen again.
Sure you hope not. Let's see about the minutes from the last meeting. Have you read them? Do you know what they say? Do you have comments about them?
I read it, was okay to me.
As good as they stand.
I just had a couple of things here. Let's see. I have one comment that I don't know what it means. On page 2, in the third paragraph, it says the board considered which possible appellant to hear first and decided to hear Mr. Doherty first. I think actually what we decided was that it wasn't a matter of first, but that we could only hear one case in this situation, and we did decide that it was Mr. Doherty, but not that we were going to either weigh them against each other or hear one and then the other.
What I meant by that was if the case was going to be heard twice.
Okay. Okay, but I guess, okay, I was just trying to make the point that night that we weren't going to hear one after the other. Okay. And then on page 3, sort of in the last quarter of the page, in the paragraph that starts, the zoning administrator asked to speak again. At the end of that paragraph, it says the zoning administrator noted that the 800 square foot footprint, okay, My question is, later on, when we get to the motion, at the end of the findings, it said that Mr. Gruser suggested that Mrs. Howell suggested the plan have a larger rear setback and come closer to the 600 square foot print. So if that's what I said, that's fine, but it's confusing because one time we say it's 800 and the next time we say it's 600.
We can just check the tape.
Okay, and maybe I did say that, but I think it's confusing in the minutes because it's not clear how big the thing was actually going to be. Okay, those are my comments. So have we got a motion to approve the
I move to accept the minutes with the clarification on as Betty mentioned.
Thank you. And the other business tonight is that we are supposed to have a procedures meeting to establish what to do next. And I think we have the rules of procedure, and I think we need to determine who's the chair, and maybe Mr. Pearson wants to direct us a bit on that.
Several years ago, as a matter of fact, when Mr. Weil was chair of the Board of Zoning Appeals, there were revisions to the previously existing policies and procedures. I think they functioned well. You've had a chance to look at them, hopefully. I don't really think there's anything in there we need to change unless you see something. This is the opportunity to do it.
I got a question on the page, there's no page number, but Article 4, number 2 is about the special meetings. If the chair calls for a special meeting within 48 hours, that can be for hearing a case, right? We cannot have a special meeting to hear a case within 48.
No. Okay. And I'm not sure what that's in reference to be honest with you. But no, you can't hear a case without notification of adjoining property owners.
Well, so what is the special meetings may be called by the chair or at the request of 2 members, provided notice of same shall be given to each member at least 24 hours before the time set.
I think that's if we want to get together and discuss something.
Some issues, some specific issues.
But that has to be public, right?
Right. It has to be an open meeting. You can't have in other words, it has to be announced at least that far in advance. You couldn't consider a case. Let me give you an example of when that might happen. Early on in the zoning code, it talks about the Board of Zoning, in your section, the Board of Zoning Appeals can call upon any city department, function, person, whatever, to give testimony. Say, for example, you need some information from the sewer department, and they can't come tonight. You could call a special meeting to take their testimony.
Okay.
I think that would be an example of that. You couldn't make the decision right then, but that would be the opportunity to get that information at a more convenient time.
Okay.
That would be outside of that. I can see special meetings probably only taking place after you've started hearing a case. You do have the ability to take, I believe it's up to 60 days to make a decision. I can't remember the exact number, but even though the board makes decisions normally the same night the cases are heard, you do have the opportunity to extend that time if you do have some additional questions, other information you need, or you need to call it upon some other city department or administrative member.
And one more item, you have references to these section numbers. Are they up to date with the new, like 23.95? There was one that didn't match the one that I was looking at.
I'll check all of those to make sure. City Council pretty routinely modifies and revises development ordinances in the city. And when you have things stated, that's, to be real honest with you, it's a lot of time, the clerk of council and I are talking back and forth because you change one section of one code way over here, and if you've got other things that reference it, all of a sudden all your reference numbers are bad.
Yeah.
So I'll check those too.
And then you are also called zoning inspector throughout the whole thing. Is that title changed now? So maybe that can be changed also.
All right. I can do that modification. What happened was in the revision of the zoning code in 2003, zoning inspector has the idea attached to it that I'm going out and work clothes and blue jeans every day, looking at things where I wish I had more opportunity to do that, and I look forward to doing that when the city planner finally arrives and can take over some of these.
Don't hold your breath.
Some of these other things that I've just been delegated in the course of my employment with the city. My background is in inspection and construction, not in administration.
Okay. I knew we changed yours.
I'll change it to administrator, because that actually is what the code says now. That 2003 change it from zoning inspector to zoning administrator, because my duties now are a lot more administrative than inspectorly. I don't feel like Inspector Gadget or anything like that.
And then it talks somewhere about the time limits, that who gets how much. You talk like 5 minutes for a Steve and 15 minutes for, do we want to stick with that or change
Is
that?
it in here?
Yeah.
Yeah, we said it.
It's just a guide. It's all.
Yeah.
Yeah, the slate of it.
Yeah. I think it's,
We brought
yeah.
that up.
Yeah,
But yeah, I
So
mean,
we're not gonna keep the
I
time.
think that's good. Okay, code inspector,
just
code
so it's
director,
there,
5 minutes,
we cut somebody
appellants,
off.
15 minutes, okay. That seems good.
Keep
That
it
seems good.
Okay.
filibustering, I think it's called.
Yeah, right. That seems like good information.
The slate.
Anything else?
No, that's all for me.
We can make those minor changes, and then I'll get new copies to you. The only other thing you need to do tonight is appoint a chair, and really that's kind of a legalistic, procedural kinds of thing, because I send notices out, and they have to be under someone's signature.
We select Muriel.
I suppose she can't be here to refuse the nomination.
That's what happens when you don't go to the meetings.
Well, she's proved herself to be a good chair, and so we want to keep her on.
I know Mr. Sligo is very concerned that the board has, he didn't think it appropriate, he had like a rotating chair. In a way, I kind of agree, because
Well,
they're.
we don't really. We
But you
have
know,
Ms.
I mean, what I'm
Frederick.
saying is somebody's name has to be
Right.
attached to
We
it.
have Mrs. Frederick, and then when she's not here, we.
And the more often you chair, the more comfortable you get with that.
Right, and I think it is a good opportunity for everybody to have an opportunity to do it. It's a little different perspective when you're in charge of the meeting. I think Mr. Lavelle pointed out, when somebody does, get a little windy, it is the chair's position to, have to say, well, we have this 5-minute limit, and it's a little different perspective, I think, when you're in charge of running the meeting. It's a good opportunity, I think, for everyone to take a chance, but I just need somebody's name. And so I don't have to change my forms. If you have a name and nomination that's unanimously approved, I'll continue to have Muriel Frederick as the signature line.
Unanimous.
I sign everything anyway, so I initial her name.
And was her term was
expired?
renewed again, or is she renewed?
I believe so. Ms. Hollow's term, Ms. Frederick's term both expired. I did just receive a document where you signed to continue to be a member and were endorsed by council. I talked to the mayor, and I'm not sure why I don't have that same document from Ms. Frederick, but probably because she's not back in the country yet. So as far as I know, council has confirmed the mayor's nomination, and we're just awaiting her return for her signature on that document.
So maybe that's all we need to do.
I think that's it.
I think that's it. I think we're adjourned. Thank you very much.